Justice and Accessibility Legal Fellow. I've been with the organization for it'll be 2 years in September, so about a year and a few months. I assist with our disability discrimination, reasonable modifications, reasonable accommodations, and our reasonable accommodation modification complaints, and with our Adele Friedman Housing Accessibility Fund. This PowerPoint presentation will be an overview of some of the services we provide related to disability, as well as an overview of our Adele Friedman Housing Accessibility Fund. Of note is that the Fair Housing Justice Center assists with fair housing matters, which are distinct from landlord-tenant and affordable housing matters. They intersect in many ways because a bad actor landlord who may be refusing a modification is likely to also be one who refuses general repair. But sadly, we only assist with fair housing matters,
Recording
not
in
with.
progress.
No worries. Sorry, recording started and it surprised me. So I'm going to continue with my presentation now. So, what's the Fair Housing Justice Center's mission? We hope to eliminate housing discrimination. We want to promote policies and programs that foster accessible and open communities. We want to strengthen the enforcement of fair housing laws. So, we'll review some of the ongoing fair housing laws that exist in New York City and New York State, as well as federal law, which is the Fair Housing Act. And a lot of the work Fair Housing Justice Center does is uphold those laws. We act as a regulatory factor in many ways, and worker. We have folks who provide assistance with exploring complaints and finding ways to collect evidence. We help folks navigate the facts of their experience. If something leaves a bad taste in the mouth, we go in and we navigate the facts. We identify if it's a fair housing matter or not, and we help with next steps. We work in all five boroughs of New York City, and we do the seven surrounding suburban counties, which is Dutchess, Nassau, Orange, Putnam, Rockland, Suffolk, and Westchester. So we're about roughly 65% of the New York State population, which is around 3% of the US population. So we have a very large service area. Here's a review of some of our programs. We do intake, so folks who call us and who may have had an experience of housing discrimination will reach out to our intake team. They'll do a call, they'll take on information and collect it, help determine if it is a fair housing matter. We do counseling, so we help folks navigate their fair housing matters. We do testing. We do legal referrals. We can never promise a legal referral when someone reaches out to us because the reality of attorney access is that there are going to be circumstances where attorneys may not be able to take on the case, or in which a fair housing attorney may be way too inundated and overwhelmed and just burdened, not burdened in a bad way, but like the reality is that they don't have capacity. We also have the Adele Friedman Housing Accessibility Fund. I will go more into that, but essentially, the Fair Housing Justice Center has money set aside to specifically assist with assessments and the production of reasonable modifications for individuals who qualify. We also do proactive investigations to document and eliminate systemic housing discrimination. We do fair housing advocacy on policy issues. One our policy head just recently assisted in a huge and important change that work towards changing how housing providers are allowed to respond to individuals with a criminal background. Because oftentimes housing providers will deny, and that was allowed for many years. Now there's a lot of really good pushback. We do education and outreach activities like this one, and we do technical assistance and training. About twice a year, we run a training for lawyers and architects that expands upon reasonable modification and accommodation practices and how to best assist individuals navigating the world of disabilities, and how to best practice and provide resources without breaking the law. Because lots of folks will just say no and not participate in a verification process that ensures access to the full use and enjoyment of your home. So, basics of housing discrimination. You cannot be discriminated against in housing because of protected characteristics. What are protected characteristics? So, we have three fair housing laws that will affect individuals, especially if like going from New York City to New York State to the rest of the United States. Under the Federal Fair Housing Act, protected characteristics include race, religion, color, familial status, so the presence of children, sex, this includes sexual orientation and gender identity, national origin, and disability. Under New York State human rights law, we have age, marital status, military status, lawful source of income. So that can include your voucher status or your employment. Very quick note, we see a lot of folks experience discrimination on the basis of voucher status, as well as individuals who may be practicing attorneys have experienced lawful source of income discrimination. Some landlords don't want a housing attorney to be their tenant. We also have domestic violence and sex offense stalking victim status, immigration, and citizenship status. So that's under New York State human rights law. And it kind of exists as like a silo. So everyone is protected under the Federal Fair Housing Act. An individual who's in New Jersey is not going to have the same protected characteristic documentation and encompassing protection as under New York State human rights law. And then for New York City, you also have lawful occupation and domestic partnership status. So if you live in New York State, so if you're in Westchester and you're not under New York City human rights law, you do not receive that protected characteristic protection. It's kind of like a silo. If you're in New York City, you have both New York City human rights law, New York State human rights law, and the Federal Fair Housing Act. If you're in New York State, so outside of the five boroughs, you have New York State human rights law and the Federal Fair Housing Act. But let's say you have a lawful occupation uh, protected characteristic attack, and you're not in New York City, you do not have a claim. Who cannot discriminate against you? This is everyone involved in providing housing. This includes landlords, your super management companies, sellers, real estate agencies and banks, facility operators, your co-op board, lenders, insurance companies, appraisers, and in some circumstances, neighbors. There was a case recently that changed the way in which you could get like and standing and fight back against if a neighbor is discriminating. So just want to highlight that just because it's important. These changes happen. The attorneys who work in fair housing law are brilliant and continue to acclimate to ongoing changes in the law. A very natural experience of being a lawyer. What counts? What's housing discrimination? Housing discrimination is differential treatment based on a protected characteristic. Examples that we've seen at the Fair Housing Justice Center and uh, throughout the country includes lying about availability of apartments, ghosting. So, quick example of ghosting is, let's say you're a city FEPS voucher holder, or you have a Section 8 housing choice voucher, and you're going around outside of specifically like public housing, and you tell a housing provider, "Hey, I have a voucher," and all of a sudden you don't get any text back. That's called ghosting. It's a very gaslighty way to communicate with people because then they just stop responding, and it makes you wonder maybe it was another issue, but nothing is concretely stated about what their reasoning for abandoning the conversation and not providing you with the housing was. They will just kind of disappear. They kind of ghost. They're invisible. Part of it can include providing worse services to you. You may see that white tenants receive more assistance with their regular building issues, and a black tenant may be completely ignored. Harassing you, sometimes concrete responses of saying, like, you shouldn't be here because you're disabled. I'm upset that you utilize a wheelchair or are an individual who experiences incontinence and utilizes a diaper and other services. This includes steering from certain neighborhoods or areas of a building. You'll see the creation of segregated neighborhoods that is ongoing and present in the United States via housing providers and realtors identifying towns in which white people are placed and towns in which Black people are placed. Making any statement that indicates a preference, limitation, or discrimination. Sorry, one moment. My Zoom bar covered my text for a second and I could not read. Preference, limitation, or discrimination. This could also include refusing to allow reasonable accommodations and modifications. So we'll go more into accommodations and modifications, but someone could request the creation of a ramp in a common area that under New York City and New York State law has to be provided by the landlord. They could just be like, we're not doing it. There's no reason. We've completely denied the conversation. It's ending here. We are not providing you with assistance. They have to follow a reasonable process. There has to be some form of communication. It can't just be ghosting and denial that will oftentimes fall into a failure to provide a reasonable accommodation or modification. One moment. Okay. What housing is covered? Most housing for rent or for sale. So this is apartment buildings, condos, co-ops, single room occupancy, SRO units, supportive housing, transitional housing, publicly assisted housing, mobile home parks, nursing homes, assisted living facilities, and retirement communities. Fair Housing Justice Center has had cases where we have sued assisted living and additional programs that provide temporary and long-term support for individuals. In New York City, for a while, housing providers who were assisted living facilities and adult, my brain is forgetting the other acronym and I apologize for that, where these programs were refusing to house people who were wheelchair users, refusing to provide assessments to individuals on the basis that they utilized a wheelchair, regardless of the services that the provider was able to give or legally allowed to provide. They just were discriminating like point blank. If you utilized a wheelchair, these adult living centers and assisted living facilities would just immediately deny access. So we've had a few cases that are upholding the law to ensure that individuals who utilize wheelchairs get equal access to assessments. Because there's absolutely no reason that there should just be a point blank denial on for someone who utilizes a wheelchair. Um, for retirement communities, you can often see cases, or there are cases in which there's discrimination on the basis of celiac diagnosis. Individuals who have celiac may experience cross-contamination on the basis that there is a failure to train folks, and then they get incredibly sick. We'll continue now. What's not covered? So there are three situations in which the Fair Housing Act and fair housing laws are not covered. This includes one or two family buildings where the owner lives. Rooming houses, it's not covered for sex discrimination only. And for a certain age or family specific housing, they're not covered for familial status discrimination. So, for instance, like discounts for seniors 65 and older are permitted. We will now move on to disability housing discrimination. What are the fair housing rights of people with disabilities? So, disability is a protected characteristic under federal, state, and local fair housing laws. You are protected from disability discrimination in all aspects of your housing. You cannot be treated differently by landlords, sellers, agents, bank, management companies, or anyone involved in the housing process because of your disability and disability status. People who currently have a disability, have historically had a disability, or are perceived to have a disability are all protected. So there are cases in which individuals do not have a diagnosed disability, but may be assumed to have a disability, who have experienced discrimination, who do qualify and are identified as individuals who have experienced discrimination on the basis of disability status. How is disability defined? It varies by legal jurisdiction. Federal Fair Housing Act defines disability as a mental or physical impairment that substantially limits one or more major life activities. Under New York State, we have a broader definition. This refers to a physical, mental, or medical impairment or a record of an impairment which prevents the exercise of a normal bodily function or is medically demonstrable. New York City law defines disability even more broadly. So it's any physical, medical, mental, or physiological impairment, including a full range of sensory, mental, physical, mobility, developmental, learning, and psychological disabilities. So again, the more area, the areas are siloed in a way, you get more protections under New York City and more of a larger definition. And New York State has a larger definition than the General Federal Fair Housing Act. So all folks in New York State receive the definition of a recorded impairment. In New York City, it's even more broad. Examples of fair housing disability housing discrimination. So this could be very similar to the other slide I provided that were examples. Refusing to rent to a tenant. Steering, so they may put folks with disabilities in certain properties or neighborhoods or in other areas on stereotypes or assumptions about their needs. It's the act of not listening to what someone is asking of you. If an individual with a disability wants to live in a certain part of town, they should receive access to housing in that part of town. But some providers will look at an individual with a disability and assume, oh, this person should live here, or I'm putting them here because I don't want them around able-bodied people. This could include rejecting a rental application because the landlord is uncomfortable renting to someone with a disability or whose partner or family member has a disability. There have been cases in which individuals who utilize wheelchairs and diapers have gotten home and just do what many of us do when we get home, in which the individual will like take off their diaper, throw it to the side, hang out, and the landlord is pissed off. They think that the individual should not be allowed to do that. Um, but then if, let's say we compare this to an individual who's able-bodied, who doesn't utilize a diaper, who takes off their pants and throws it to the side, the only difference is the identification of disability status. And that landlord, if this were in the rental application period, a denial on the basis of disability status would be an example of discrimination. It includes isolating individuals with disabilities in specific units or areas within the housing complex, effectively segregating them from other residents. It could be, oh, we've put every single disabled person on the first floor, and not all of them need immediate access to first floor exits, but simply we've created the area where people with disabilities live. It could be requesting unnecessary medical information or documentation related to a disability during the application process. So there's an extent to which your housing provider is allowed to request for medical documentation, but they do not need access to your entire medical history. A letter that documents your accessibility need suffices. It also includes refusing to make legally required modifications or accommodations. A housing provider can deny a modification or accommodation on the basis that it's administratively or financially unreasonable and inaccessible to them. For instance, a building may not be able to have an elevator installed because the landlord can't afford it, and additionally, the landlord and the building will crumble if an elevator is added. So let's say they've gone through the whole process, they haven't just immediately denied. They said, let's look into it and figure out what we can do because I have a legal obligation to look into this and see what I can do. And then they find out if I add an elevator to this building, it will fall apart and it's not possible. But then there's always and should be room for creative solutions. Reasonable accommodations. What are reasonable accommodation requests in housing? So, individuals with disabilities have a right to request that the rules or policies of the building where they live be altered to allow full use and enjoyment of their homes. We'll go into modification in a moment. I just want to highlight accommodation is change to rules or policies. Modification, which we'll go into, is a change to the physical dwelling to ensure full use and enjoyment. In order to request an accommodation, this request can be made by you or someone acting on your behalf, such as a family member. Any form of communication works, but we highly recommend that the communication is in writing. If you call your housing provider, because that's the most accessible tool for you, we recommend immediately after having someone assist you, or if you are able to then contact your landlord or housing provider via email to state exactly what you talked about and document exactly what you talked about and what your housing provider said, because then you have a date stamped document of communication. It's very easy with verbal communication for a housing provider to say, we never talked about it. I didn't say that. XYZ didn't happen. If you communicate initially via email, you have concrete documentation of how your provider responded. And that can be super helpful if the case goes to court. If you need to show and document dates, it is imperative to have some form of physical documentation of the conversation. What are examples of reasonable accommodations? An accommodation can include a transfer to a first floor unit or a more accessible unit. So let's say you live on a floor that happens to have 1,000 dogs on it and you are highly allergic to dogs. If there is a unit available on a different floor, you are able to request on the basis of your allergy to be moved to a more accessible floor, a floor maybe with no dogs present. It could be supplying a lease application in a large print so that it's more visually accessible to your needs, providing an ASL interpreter at a tenant association meeting, assigning a person with a disability a reserved parking spot near their unit, even though tenant parking is generally on a first come, first served basis. For parking, it can also include, if there's no parking available, the creation of a wait list where you are then placed as number one to receive the next available parking spot. It could be making exceptions to residency requirements to allow a home health aide to move into the apartment. So, for instance, if you have a unit that the housing provider is like, there's only one person allowed in here, you are able to say, I have a full-time home health aide. I need this person present in my home so that I can function and have my needs met. I need to change to these rules or policies. It could be allowing a person with a disability to keep an assistance animal despite a no pets policy, which I want to quickly note. ADA does, we'll go into emotional support animals in a second. There is a slide on it. ADA for emotional support animals, there is no protection. It's a like there's the threshold is really high. You cannot bring your emotional support animal onto an airplane. You can't bring them into restaurants. ADA requires very specific training for a service animal. An emotional support animal doesn't fall into that definition in most circumstances. Uh, for housing, your emotional support animal under the Fair Housing Act and fair housing laws, you can have an emotional support animal with a therapist letter be present in your home. The animal's presence is a change to rules or policies. While you can have that animal in your home, you are most likely, because of its emotional support animal identification, not able to put that animal on an airplane. There can also be cases in which, let's say you are experience a suit on the basis of the amount of emotional support animals you have, you may experience a hard time proving that all of those animals are reasonable. The basis for an accommodation, again, housing providers can push back on a reasonableness standard. Uh, there may be an argument if you have 9 emotional support cats that 9 may not be a reasonable amount of cats. There have been some circumstances where you're able to argue if you can identify what each cat does for you and your emotional support needs, you may be able to push back, but it's a little bit harder than if you have a smaller amount and can prove reasonableness. The last one we have is an example, and these are not like concrete, like again, like anything that you can see as an accommodation, so long as you can argue reasonableness and can show that there's no undue financial or administrative burden. Like it's this is not the only these are not the only accommodation. The last one is adjusting the rent payment schedule for a person receiving disability checks later in the month. So you could say, hey, I can't pay the first of the month. I don't have the money in my bank account. I'm only allowed to keep XYZ amount because I received this service. But by April 15th, I'm going to get rent and I get this consistently. Can we change the schedule to this schedule? It's based on my disability status. It's based on my disability accommodation need. And that can be found to be a reasonable accommodation. Do I have to provide documentation or verification of my disability? It depends. If your disability is invisible, so disability where you may not have a visible mobility aid, a disability that may be a chronic illness that doesn't utilize visible medical equipment, you may need letters from a medical professional, a social worker, or other professional. These letters can help explain how the accommodation is necessary based on your disability. In my experience at the Fair Housing Justice Center, I find it helpful in most circumstances, regardless of invisible or visible disability status, to get a letter if you can. If there's an incredible hardship and you have a visible disability, you can say, I'm an individual who utilizes a wheelchair and I need X, Y, and Z. You don't have to send them the photos of your wheelchair. You could just say, I'm an individual who utilizes a wheelchair. But if, let's say, you have allergies or a mental health disability that requires soundproofing in your walls or to be transferred, you will need a medical letter from a doctor. I just recommend if you have access to it and it's not a financial burden, and you have a visible disability, I still think it's helpful, but it's not always required. Can I be charged an extra fee for having my accommodation provided? Nope. Housing providers are not permitted to charge a fee for providing a reasonable accommodation. So we can talk about pet deposit fees or fees for assistance animals. They can't be collected. Maybe your housing provider requires that people pay a little bit extra in rent for pets. An emotional support animal, a service dog, is not a pet. It's a medically necessary animal. It's providing you a service. It is not okay to then have to pay a pet fee because of a reasonable accommodation pet service animal. So no, they can't charge you more. They can't charge you more for or give you a fee if you're paying rent later in the month. That is not okay. That is not allowed. That is a violation of your fair housing rights. So we can move on to reasonable modification requests. So before I go to the next slide, the distinction between accommodation and modification is that an accommodation is a change to rules or policies. So your service animal is allowed to be in your house in a unit that usually would not allow pets. You're paying rent later in the month because that's when you receive your check. Those are all examples of accommodation. Modification is a change to the dwelling, change to the physical aspects of your dwelling to ensure full use and access. So, if you're an individual with a disability, you may request a structural change to the unit or common areas in your building. Housing providers are required by law to provide reasonable modification to tenants with disabilities. Who can request a reasonable modification? Same as for accommodation. It can be made by you or someone acting on your behalf. Examples. Modifications can be ramps to overcome steps at the entrance to a common area. Can be lowering the entry threshold of a unit. So that's like as you enter into the doorway of your unit, there may be a bump. It could be lowering it so that if you are utilizing any mobility aid, you don't get stuck. You don't risk falling. It could be installing grab bars in a bathroom, widening entryways into a bathroom. So a lot of buildings pre-1991 were not obligated to follow fair housing design and construction guidelines and are built in ways that do not structurally allow individuals who utilize mobility aids to enter and exit safely. Uh, you are allowed to request the widening of these doors so that your walker, your wheelchair, you and your cane can go in safely and not hit a wall and again also fall or risk injury. It could also include providing a flashing doorbell. If you're deaf or hard of hearing, you can request the creation and introduction of a flashing doorbell so that you know when someone is at your front door. Again, the same with documentation and verification. If your disability is visible, we recommend that like there's notes that you don't need to have a modification request letter. If you have an invisible disability, it can be helpful as well to have that letter because it proves your accessibility need. While a visible disability, you can say, I utilize a roller door, like all these additional things. Who pays? So in New York City, and I know that your organization is Westchester based, so I will expand on that in a moment. New York City, landlord or housing provider is almost always required to pay. In New York State, counties located outside of New York City, the tenant is usually financially responsible for the modification. From my understanding, sometimes common areas are a little bit different, and your New York State housing provider may be obligated to pay. And with the reality of the cost for modification and the reality in which New York State does not require housing providers to cover the cost, the Housing Justice Center has a program that we call the Adele Friedman Housing Accessibility Fund. In this fund, we provide financial assistance to low and moderate income renters with disabilities who require reasonable modifications to their homes. We also provide assistance to individuals who may have historically owned their home, but who now are in their homes via disability trust or other form of trust, where the individual who is the named um, executrix of the trust may not live in the unit. They should not be living in the unit, actually, in order to qualify. We use the fund for two purposes. So reality for units outside of New York City and modifications. Modifications are expensive. The disability community has historically been recognized as a community that has a really difficult time accessing finances and accessing uh, wealth. For individuals who receive certain disability benefits, they may have caps in the amount of money they can have in their bank account. You may have been unable to work or may have never worked because of disability status and access needs, and that makes it really difficult to then pay $20,000+ for instance, for a chairlift. That makes it near impossible to get that. So we do two things. For New York City and also New York State complainants, we compensate expert architects hired by the Fair Housing Justice Center to evaluate our reasonable modification requests and to obtain related cost estimates. And then we pay qualified contractors for work performed to make the requested modifications. This process is not quick. I have started to let folks know that it can take 6 to 9 months to get a modification between the time that we provide an assessment to the time in which we're able to work with a contractor and contract with them to create this modification to the time when the modification is finalized and installed. We do our best to push the process along. The reality is that there are going to be delays related to communication, related to deciding who the best contractor is for the project. But we do try to assist as many folks as we can in a time period that makes sense. And it can take up to 6 months and can be delayed. So to qualify, you have to be a person with a disability. You have to complete the intake process with the Fair Housing Justice Center, and we need documentation for the need of the modification. You have to maintain legal residence in the Fair Housing Justice Center service areas. So if you are Westchester based, we cover you. And you have to have a household income, which is at or below 165% of the New York State median family income. We don't, in our PowerPoint presentation, say the exact cost because it changes from year to year. Um, but we encourage folks to send in information and apply. Most folks who have reached out to us are qualified financially and we assist. If not, we send referrals to other opportunities as well. The fund is sadly not available if you or other members of your household own other real estate or the real estate that you're occupying. And if we determine that the modification request is not feasible or reasonable. So for instance, going back to the elevator in a building that it will crumble if it's placed, we can't help with that. But again, we are open to creative solutions. We want to work with you to ensure that you have full use and access, especially given the reality that New York State human rights law doesn't require a housing provider to pay for the modification. For New York State renters in our service area who receive modifications, we also ensure the addition of the removal of the modification after you leave that apartment. We've had multiple folks receive chairlifts from the Fair Housing Justice Center, and as part of our contract with our chairlift provider, we continuously add a clause in which we have prepaid for the removal of the chairlift. Just as how when you leave an apartment, you may be required to leave it as you found it. That includes, of course, like painting walls, filling holes, also ensuring that you take the modification with you or remove it from the dwelling. So we ensure that that's covered because we don't want that finance to fall onto an individual who qualifies. We want to pay for that. We want to cover that. How do we assist? So we can help make a request for a reasonable modification, and we can document your housing provider's response. And we can also assist you to exercise your fair housing rights should your request be denied. So outside of the qualifications we have for our fair housing fund, we have no requirements for the services that we provide to individuals. Um, if you are just reaching out because there's an accommodation request issue that you've like requested to pay rent later in the month to your landlord, we'll assist you. Do not get nervous about the Adele Friedman Housing Accessibility Fund. It does not apply in this circumstance. We always recommend folks just reach out and see how we can help. We may decide like, oh, like the New York City resident who like the landlord's required to pay, but the documentation has shown that they've been ignoring it or said no with no additional conversation or process, we would then push and say, let's maybe use the fund and see if this person works with like can fit into the fund, and if we can pay for an assessment, because then we can assist writing a reasonable accommodation or modification letter, or specifically modification letter, with the exact documentation and review of an assessment that would identify how much it costs. So we always like want to be creative, but our other tools other than the fund do not have uh any qualification requirements. Like please reach out, even if you think you may not qualify, just reach out. We highly recommend just reaching out. Worst comes to worst, we say we cannot assist in this matter. Here are some referrals to other organizations. Additional resources. We have a bunch of fact sheets on our website. This includes the rights of people with disabilities, modification requests, reasonable accommodation requests, and housing discrimination, letters from medical providers to support tenants' reasonable modification and accommodation requests, and housing discrimination and emotional support animals. Thank you so much. And this is the end of my PowerPoint presentation. I will keep this up for a second for folks to screenshot, and I can also share the PowerPoint uh, with Westchester Disabled on the Move to ensure that you have access to our information. But I'm going to now click stop share. If anyone needs to do a final screenshot, you have 5 seconds. I will do. Perfect. I am now going to stop sharing.
Cass, thank you so much for that presentation. I appreciate your time. And thank you for all that information. Thank you so much.
No problem. Oh no. Sure. My name is Cass Sicherer. I am the Fair Housing Justice Center's Disability Justice and Accessibility Legal Fellow. I have a background in, when I was in law school, I focused a lot on special education law, but I've always been really interested in disability law and policy. I was an American Association of People with Disabilities summer intern in 2019. I received wonderful, fantastic mentorship and education from my mentor named Lydia X.C. Brown, who I found the Fair Housing Justice Center job from, and am always grateful to learn about new opportunities. I was a Paul Marchand Fellow with the ARC back in 2021, I think. I worked at the Rutgers Education and Health Law Clinic. I have been working in disability community spaces since I was very young. My older sister we participated in and I participated in an organization called the Friendship Circle, as well as Camp Sunshine in North Jersey. And I myself navigated special education and am an individual with disabilities. And to me, fair housing has been a new way of learning about accessibility and disability justice and how to really present to folks what your rights are. Because I know for myself, navigating special ed, I like received the privilege of getting resources on what my rights were, or my parents did, and were able to advocate for me. And the reality is, access to information is power. And we're oftentimes withheld that information, or we experience discrimination, and we internalize it. So to me, doing this type of work has been a gift, because of the fact that like even giving one person information about what their rights are is imperative. And assisting folks as they navigate this process, which is a form of like crisis work, is like hard work, but it's good work. And I'm really grateful to be here and to have shared this information with you all. No problem.
Can you explain to me what it means to be a fair housing fellow?
Yeah, so my position, so I'm an attorney. I'm not licensed in New York yet. I have to fill out the paperwork. I am prepared in every other way except for filling out the paperwork. And so in my position as the legal fellow in disability at the Fair Housing Justice Center, I assist our legal director with our ongoing disability cases. So essentially, I act as a lawyer under supervision, or as a legal like a baby lawyer. I am new to the law, but I have been studying it since 2020. So I'm new to my bar accreditation. But essentially, um, I am an early career lawyer, and I am early career in the position that is essentially general counsel, but not exactly, just because I am working under supervision in the way that I am.
Thank you. And thank you again for the presentation. You did great.
No
Very
problem.
helpful.
Thank you. And please reach out to the email provided if you have any questions or fair housing discrimination can be really uh, hidden. It can feel like you're being gaslit if you, in your housing process or in assisting folks in their housing process, get kind of like a bad taste in your mouth, or you were like, that was strange, but I don't know what that meant or what that was. Please reach out. We do things called fair housing testing if the circumstance, if the stars align and there's enough units to test, where we seek out and utilize folks to identify the discrimination that was created by recreating it with actors and cameras and different things that I can't go into description with because it's very investigatory and secret. But please reach out. We have our fund available. We love to pay for modifications. We have money that is saved to do so. Process is slow, but it's a process that is helpful, and we are like not mandated by a government agency with our fund to how we apply it. So the process is really just very internal, and our funding is used via our internal decisions based on the design of the fund itself. Yeah, so please reach out. For housing discrimination is really evil. But yes, are there caps on the modifications? Um, I don't know if there are any other questions. I did see that one pop up. Not really. I would say like I don't think we could do I think it would be a discussion if a modification was around like $100,000, $200,000. But we've had and assisted with modifications that have gone up to 30,000. Um, we've done like personalized chairlift assistance. The goal is assistance. We have money in our fund to assist. And if there is a case in which it does go really high, I think that would be a discussion that we would have. But we just recommend folks to reach out and see how we can assist. The goal is really modification provide and to provide it. And if something were to come up that maybe was concerning, it would be an internal discussion. But our goal is to figure out how to provide that assistance under circumstances, under majority circumstances. If there are no more questions, please feel free to just reach out via email and additional communications as well. Thank you so much. It was a pleasure to
Thank
speak with all of
you.
you. Thank you.